Good evening, Justice Anselmo Reyes, Justice Rikumar, Dean Andrew Simester, distinguished speakers and guests, ladies and gentlemen. It is my pleasure to welcome you to the launch of the Cambridge Handbook of Private Law and Artificial Intelligence, of which I'm the co-editor. I'm Ernest Lim. I'm professor at NUS Law. I am the MC, and Justice Anselmo Reyes will be moderating the Q&A. I'd like to express my gratitude to Professor Hans Jo, Director of the E.W. Barker Center for Law and Business, and Associate Professor Daniel Seng, the Co-Director of the Center for Technology, Robotics, AI, and the Law, for their generous support. I would also like to thank my esteemed local and overseas colleagues who contributed to this handbook or who commented on the draft chapters. You will hear from some of them later on. For those of you who need CPD points, please remember to sign in. May I gently remind all speakers that you only have 10 minutes to speak. Dean Simester will now deliver the welcome speech. He is a world-renowned authority in criminal law and theory. Over to you, Dean Simester.
Distinguished guests, colleagues, ladies and gentlemen, as is traditional on academic occasions, we're already running late, so I'll keep this short. We're gathered here today to celebrate not a wedding, but a birth after a rather lengthy gestation of an important book. The Cambridge Handbook of Private Law and AI is the first systematic treatment of the challenges that AI poses for private law around the world. Now, of course, technology has a long history of prompting legal evolution. The Industrial Revolution transformed the world. It changed our lives, and it changed the law. With it came laws governing working conditions, the beginnings of a health and safety system, and for the first time, the legal phenomenon of strict liability. A new regulatory universe was born. And later, by 1932, as we all know, the interaction of mass production with third-party distribution chains necessitated the most famous of all tort cases, Donoghue and Stevenson. Now, in many ways, AI is similarly transformative. But this change is a little different because it's been so much faster. Admittedly, it was possible to take electives in AI programming back in the 80s. In fact, I did. That's the 1980s, just in case. Back then, though, the potential of AI was very limited because there simply wasn't enough computing power. It wasn't, for example, until 1987 that an AI system could beat a world chess champion. Beating a world Go champion took another 30 years. But it was always going to happen. It was just a matter of time. The growth of AI across the last 30 years has been exponential. Now, AI doesn't just win at board games. It drives cars. It detects fraud. It diagnoses cancer. It runs factories, etc., etc. Like it or not, AI is pervasive. Directly and indirectly, it is part of all our lives. And just as it pervades our private lives, so does it challenge our private law. How do we assign responsibility when autonomous systems make decisions? What becomes of traditional notions of ownership and control in a digital world where machines can generate intellectual property? How do we balance innovation with the protection of individual rights? These kinds of questions are not merely theoretical, they're practical and indeed urgent. Now, fortunately, we now have a major resource with which to engage with such questions. The editors, Ernest and Phillip, are to be congratulated for curating a book that will, I am sure, help to shape the discourse on private law and AI for many years to come. And of course, that's one of the core functions of a law school, to foster the development of a legal system that is both forward-looking and grounded in the guiding and enduring principles of justice. And in that spirit, I would like to congratulate not just the editors, but all of the contributors, including academic colleagues who are with us from NUS and beyond tonight. I congratulate you for being part of the global conversation about how, both within and outside Singapore, we can navigate the challenges of AI while upholding the values that lie at the heart of private law. And now, it is time to hear from those contributors. I look forward to a thought-provoking and enriching evening ahead. Thank you.
Thank you, Dean Simester. We'll now hear from Justice Aedit Abdullah, who is judge in charge of transformation and innovation in the judiciary. He sends his apologies that he could not attend in person, but we have his pre-recorded speech.
Good evening. It is a great honor for me to have been invited to speak at the launch of the Cambridge Handbook of Private Law and Artificial Intelligence. I'm very sorry that I'm unable to attend in person. The Cambridge Handbooks are an important contribution to knowledge, capturing state-of-the-art thinking across a broad spectrum of areas, including the law. This evening's launch of the Handbook of Private Law and Artificial Intelligence continues that august tradition. The launch celebrates a timely, essential, and substantial contribution to the learning in an important area of law by an unparalleled collection of contributors. I must commend Professors Lim and Morgan and all the authors for the launch of their work. The interaction and interface between artificial intelligence and the law has clearly great currency. There is a lot of hype, excitement, and even fear about AI. Hundreds of billions of dollars have been forecast to be invested. The power consumption of training AI models is already said to be equivalent to that of a small country. Belief in AI has primarily driven the recent and not entirely spent bull run in the stock market. While there might be over-enthusiasm and optimism in the benefits of AI, as well as hopefully unfounded fears, it is clear that AI will have a substantial and real impact in many areas of our personal and professional lives, and that will extend to the legal field as seen in the coverage of the topics in the handbook. For one, the impact of AI will clearly be greater than that of the internet. We could not have foreseen in the mid-1990s, with the advent of the World Wide Web, where the changes then would take us. Few, if any of us, would have foreseen in 1995, as we were grappling with dial-up modems and waxing lyrical about great age of worldwide sharing of information, with nary a thought about corporate dominance, that on the eve of 2025, we would be faced with constant concerns about the prevalence of fake news, the information would be limited to 140 characters, and that book talks, demurity, and fast fashion would indeed be a thing. Whatever changes have been wrought by the availability of information and interaction online, it would seem that a shift of a vastly different magnitude will be affected by AI. AI's threat and promise is not just about communication and interaction, but about decision-making, the creation of novel works, and indeed, even thinking and imagining, or at least perhaps a possible simulacra of such. I suspect where we will end up will not be either a utopia or a dystopia, but somewhere in between, though it remains to be seen whether the end result will be closer to the light or to the dark. But while we cannot predict precisely where AI will take us, this uncertainty does not mean that we should not think about and prepare for the issues and challenges that will surely be engendered by more widespread adoption and deployment of AI in all aspects of human life. Such preparation must involve thought and consideration, probing and critiquing what we have, what we are thinking about, and what we propose to do. The Cambridge Handbook is important in laying out considerations across a whole slew of areas in private law. I must congratulate the editors and contributors for wide-ranging yet deep, stimulating analyses and discussion across these areas. This will catalyze further probing and examination, helping the legal field to come to grips with the challenges of AI. Such exploration of new areas is important for the rest of us in the legal field. Too often, especially in common law jurisdictions, academic analysis is treated as being too remote and unconnected to the coalface, where lawyers and judges labor. That characterization is too superficial and ignores the real benefit to be obtained by clear-headed critique and questioning of doctrine, practices, and case law. I would emphasize that examination of issues by jurists is always to be welcome, but particularly so in respect of new burgeoning areas. It is important to have a broad perspective unconstrained by the urgency of dealing with the immediate demands of a pending transaction or hearing, with examination of approaches across jurisdictions and across disciplines. There is indeed much to learn and many to learn from. Academic analysis helps the rest of us in the legal profession plumb the full depths of an issue, and the quality and relevance of such analysis is doubly reinforced when those involved, such as the editors and authors of this collection, bring experience and understanding of the challenges of daily legal practice into their analyses. This work lays the ground for thorough consideration of the issues and challenges to practice and doctrine, requiring a full weighing, often of policy choices, and requiring an unpacking of concepts and testing their continued relevance in the face of novel situations and demands. It may be that the readers, whether students, other academics, lawyers, policymakers, or judges, may not entirely agree with the conclusions of the writers, but consensus is never the objective. There will always be different perspectives and understanding, but the identification of issues, the consideration of factors, and advocacy of different approaches is important in highlighting areas of concern worthy of further debate, discussion, and exploration. The handbook is indeed comprehensive and deep. The chapters in the handbook cover a very broad range of areas spanning the whole range of private activity governed by law in most common law jurisdictions: contract, torts and trusts, property law, intellectual property, commercial law, and dispute resolution. Importantly, the volume brings in comparative approaches across the world. The comprehensive discussion underlies the sheer breadth of the possible impact of AI. The issues delved into go to the attribution of responsibility and agency, as well as the autonomy in systems using AI. The risk of such use, such as bias, as well as safety and security, and the need for modification and adaptation of existing legal doctrine, as well as the impact of AI and human discretion and power. There will be much to ponder over. That comprehensiveness, depth, and quality of analysis mark this book out as a seminal work that I'm sure will influence and inform law reform and judicial deliberation and transactional structures, and will no doubt be constantly cited for years to come. Let me, before I end, note that the judiciary in Singapore, as in other parts of the world, has been working to anticipate and prepare for the impact of AI in the law and on the system of justice as a whole. Several of my colleagues have thought about similar issues, presenting their views extrajudicially on occasion, such as the impact of AI in specific areas, including intellectual property law, as well as more broadly. As the judge in charge of transformation and innovation in the Singapore judiciary, I am part of a team working to see how AI can be responsibly harnessed in the courts. Aside from transcription and translation, as well as case preparation assistance for judges, we are actively working with Harvey AI in examining the use of AI in facilitating access to justice, especially for self-represented persons in pursuing small claims, where lawyers are not allowed to be part of the process. The various judiciaries in the region and beyond are also active in discussion and cooperation with each other to ensure that best practices are adopted in pursuing the use of AI. I'm sure my judicial brethren will find much useful in the handbook and will be sure to pursue collaboration wherever possible with the various authors. I congratulate and wish Professors Slim and Morgan and all the contributors all the best and look forward to further editions of the work. Thank you.
My thanks to Justice Abdullah for his thoughtful speech. Rest assured, it is not deep fake. It is a trite observation that transparency and explainability are among the key principles or guidelines regulating AI that have been set out by major governments and organizations. Transparency refers to the communication of appropriate information about an AI system to relevant people. Explainability refers to the extent to which it is possible for relevant parties to access and understand the decision-making processes of an AI system. But what does explainability of AI systems mean in the context of private law? What is private law's response to this principle? There is surprisingly little critical analysis of these questions. So rather than giving you a summary of each chapter in this handbook, there are 29 chapters covering all major areas of private law, including law of obligations as well as corporate and commercial law. Let me just give you a taste, just a flavor of the varied and interesting analysis in this handbook by briefly examining how transparency and explainability play out in 5 areas of private law: causation, contract law, consumer protection law, insurance law, commercial dispute resolution. Causation. Causation is a critical doctrine in private law remedial liability. In claims for compensation, the claimant must show a causal connection between the defendant's conduct and the claimant's loss. To rescind a contract due to a vitiating factor, the claimant must establish that the vitiating factor caused him or her to enter into the contract. Sandy Steele, in his chapter, asks us to consider a hypothetical. Suppose an AI system is tasked to buy certain products from a company. Assume that the issue is whether the AI system relied on false statements made by the company whose products it bought. How do you show the company's misrepresentation had a causal impact on the AI system to buy the products? There can be 2 answers. First, the easy and misconceived answer is that the AI system is just a black box. There is no way to find out whether, let alone how, the AI system relied on the misrepresentation. The second answer is nuanced. If the inputs to the AI system at the time of the entry of the transaction were changed to exclude the specific misrepresentation, what would the output have been? This is known as counterfactual explanation. Advances in machine learning suggest that this is possible. But the second answer depends on the fact that we can find out the inputs. What is private law's response if the defendant fails to collect or record the inputs? One answer is that a legal duty should be imposed on the developer to record the inputs. This is the approach taken by the proposed EU AI Liability Directive. But what if it's impossible to find out the inputs? There are 3 approaches. The first is to ask whether the breach of duty materially increases the risk of injury or losses suffered. The second approach is that it is possible to have causal knowledge without knowing the precise mechanisms. For example, tort lawyers know that asbestos causes mesothelioma, but not precisely how. The final approach is to adopt a statutory presumption of causality. For example, under the EU AI Liability Directive, a presumption of causation will exist between the fault of the defendant and the output or failure of the AI system to produce an output if certain conditions are met, such as the defendant having breached the duty of care. In short, the extent to which the AI system is transparent and explainable has an impact on whether we can establish causation in private law claims. Contract law. Tony Casey and Tony Niblett in their chapter argue that AI can fill gaps in the contracts. These are micro-directives which gather data about the current state of the world and factor in the purpose of the contract in order to update the parties' obligations at the time of performance. One example is dynamic price algorithms used by airlines and ride-sharing apps. But what if one party to the contract misunderstands how the algorithm is designed to function? Does that trigger the vitiating factor of mistake, which can rescind the contract? Should a court hold, on the basis of good faith, that a party who is in a superior position to understand the manner in which the algorithm functions be required to disclose or correct a misunderstanding that the other party has? Thus, the extent to which algorithms are explainable will affect the doctrine of mistake and the good faith requirement under contract law. Consumer protection law. AI consumer products, namely digital assistants, including OpenAI's ChatGPT, Amazon's Alexa, and Google Assistant. One of the issues Jeannie Paterson considers in her chapter is this: if these AI digital assistants use your data to manipulate your preferences and send you targeted advertising, or recommend you certain products that are outside the preferences that you have specified, do you have any legal recourse? For example, the Singapore Consumer Protection Fair Trading Act prohibits unfair practices. Unfair practices include not only deception or false claims, but also taking advantage of the consumer when the defendant ought reasonably to know the claimant can't protect his or her interests or can't reasonably understand the transaction. But how do you establish unfair practices? You need to understand the inputs into the AI system in order to find out if your preferences have been manipulated or disregarded. You need to be equipped for basic understanding of how the algorithms work. Thus, the principle of transparency and explainability is relevant when the claimant needs to prove that the defendant has engaged in unfair practices. But is our legislation equipped to deal with this issue? Moving to insurance law. This is highly relevant given that I assume everyone here has some sort of insurance. Insurance companies that use AI claim to be able to provide insurance quote within minutes, even seconds. AI has also been used to allocate individuals to risk groups based on their digital footprint. Under Singapore and English insurance law, the pre-contractual duty requires the assured to inform the insurer of the matters where a prudent insurer objectively would be interested in such matters. This is known as the pre-contractual duty of fair presentation of risk. To show that the assured has breached the pre-contractual duty, the insurer has to show that had the assured complied with the duty, the insurer would either not have entered into the contract at all or would have entered but on different terms. The insurer has to show the correlation between the features of the relevant individual and the predicted loss experiences of that individual, and ultimately agreeing to insure such individual on the terms agreed. This would then reveal whether what was not fairly presented to the insurer had a causal effect on the insurer's decision to insure such a risk. But in her chapter, Özlem Gürses states that algorithms are unlikely to provide simple, easily explainable reasons for the insurer's risk assessments that led to its ultimate decisions. Thus, where an AI entity assesses the risk presented, either the insurer may not be able to establish the assured's breach of the duty of fair presentation of the risk, as inducement may not be possible to prove, or if the insurers want to contend that, they'll have to find a way to prove on what data analysis they enter into the contract with the assured. This requires the insurer to know how the AI system arrived at the insurance policy. Therefore, the principle of explainability of AI system is vital to the insurer if it wants to show that the assured has breached the pre-contractual duty of fair presentation of risk. Finally, commercial dispute resolution. Justice Anselmo Reyes argues in his chapter that AI will be useful to assist adjudicators in coming up with recommendations or decisions. Adjudicators can plug into the facts of a legal problem into a Gen AI tool. Predictive AI would then output a decision based on the patterns discerned from a database of statutes and cases. For example, Harvey is capable of doing this with certain fact patterns. To address automation and anchor bias, adjudicators must know the cases and statutes relied by AI to generate the decision. To use AI to assist in adjudication, the decision makers need to have a basic understanding of the algorithms deployed. What if there are biases in the algorithms or doubts on the cases and statutes used by the AI system? Justice Reyes suggests that if a party is unhappy with the default AI system being used by the adjudicator, it should be allowed to challenge the algorithms during the relevant proceedings. This is similar to how expert evidence is being challenged in courts. Thus, explainability will be important if we want to rely on AI to assist us in adjudication. At the heart of the development and use of AI is responsibility. But responsibility raises different questions and means different things to different private lawyers. What responsible AI means to an insurance lawyer is different from what it means to a corporate lawyer. The 29 chapters in this handbook demonstrates that different areas within the law of obligations and within corporate and commercial law take a variety of approaches to addressing this question. This handbook does not give you all the answers, but it asks the right questions. Thank you. For the moment you're waiting for, let me now introduce our first speaker. He is Professor Tony Casey from Chicago Law School. He taught at NUS as a visiting professor. He's an expert in business law, finance, and corporate bankruptcy, and used to be a partner at Kirkland & Ellis. He will speak on self-driving contracts. Over to you, Tony.
All right, thank you. It's great to be here. 10 minutes is quick, so I'm going to jump right into what my co-author and I discuss in our chapter on self-driving contracts. So the idea is you have a contract that's going to fill its own gaps and write its own terms. And we talked about this first about 8 or 9 years ago, and people were like, wait, that doesn't even make sense. I'm going to try to convince you it does, although I think today with the kind of popularity of ChatGPT, people are starting to see, oh, this actually is more intuitive that this could happen. So the building block of a self-driving contract is what we call a micro-directive. Micro-directive is we started with public law, but today I'm going to talk about with private law. But the idea is you have an objective, a broad objective you want to accomplish. A law wants people to drive safely, and I'll put up a speed limit example in a minute. And your broad objective is the goal of the law. And the question is, what are the rules in any given circumstance? And the micro-directive is a message sent to someone the moment they need to perform the action that the law governs, public law or, in a contract, private law, what they need to do in that situation. And so in our early work, we came up with this idea of micro-directives, and we said, look, there's going to be machine learning, AI, all kinds of technologies, and they're going to predict things. And we can use those to change the way law works. And so the old version of law was you have a rule and you have a standard. And you have to choose between which of those you're going to have. You're either going to have a speed limit that says you're going to go 60 kilometers an hour, or you're going to have a sign that says drive reasonably. The speed limit at 60 is a rule. It's very precise. I know exactly what it means, but it's not very tailored. If it's raining, I might be driving too fast. If there's no other cars on the road, why do I have to go that slow? Drive reasonably tells me to do what is reasonable in that situation, but the judge is going to decide what that means if I get pulled over and get a ticket, and I'm not actually sure they'll get it right. They're not sure I'll get it right. And the law has to make a choice between these two things. Now, if you have the rule standard choice and you add technology, all of a sudden you might be able to get the best of both worlds. What I would really like to know is me, this person, I'm 32, I'm driving a VW Beetle on a rainy day, on a Tuesday, at this particular time. What's the speed I should go? I should go 51.2 miles per hour. If we have technology that gets all that data about those things and then predicts what the best outcome, the best safety outcome will be, and usually I think you think of the driving laws, you're trying to maximize two things, minimizing traffic and minimizing accidents, and you can weight them however you think is appropriate, and you get the micro-directive. And you're driving along your car, and it doesn't say sign, drive reasonably, sign, drive 60. Your dashboard or your windshield says you should drive exactly this speed right now. Now, this is exactly how self-driving cars work, right? They're figuring out what speed should I go based on the conditions. But the law could say this to any individual driving, and that's the micro-directive. All right, so in this chapter, what we do is we say that's a public law example. What if individual or private parties entering into an agreement said, we can use this? Normally, a contract has two types of gaps. A gap that is, we just didn't even mention what to do in a certain situation, or a provision that says something standardy, like use your best reasonable efforts. Or, you can get out of the agreement if there was a material adverse change. those are the standards or the gaps that parties need to go litigate later when the dispute arises, and they have to have someone fill in the information. And if you, basic contract theory tells us you have incomplete contracts that don't name what happens when a contingency arises, and then you have to have an arbitrator or a judge or a negotiation to fill the gap and add the content to the contract. In a perfect world, you would write a complete contract with all of the content in it at the beginning. This is impossible. You can't, even if you could think of all the contingencies, you'd have to negotiate and write them all down. It's very hard to get everything, it's impossible to get everything that might happen into a contract. You can get the important things, but there are some things that you might not predict. With the AI, with predictive technology, with the micro-directive, you can change this balance, and you can say, well, what if we have a contract that's complete in the sense we have agreed what will happen in every scenario? But we don't know what will happen in every scenario. We're just saying we'll rely on a software program that says, oh, this happened, these are the conditions today, this is what's reasonable. These are the conditions today, this is what you need to do. This is what the price is. The price changes based on the conditions. And we've committed not to have a human arbitrate the gaps, not to have a judge fill the gaps, but to have the program tell us, in this situation, this is what you do. And that's the self-driving contract. That's the idea, is that the contract is filling its own gaps. It's figuring out how to get you from A to B. And the reason we use the analogy is we think about if you are in a self-driving car, although you could do this with using a map in a normal car, you're going to say, I want to get to B, and you're going to rely on Waze or the self-driving car to get you to location B. You're going to let it decide along the way to avoid traffic, to avoid construction, and the contracts are the same way. All you need to do, but this is the hard part, is define B, right? And if I say B is a location, that's easy enough, but I want to maximize profit in our relationship. I want to, in the public law context, minimize accidents, but not too much so that the traffic backs up. You need to select the objective, and then you let the contract tell you how to get there and drive itself from A to B. It determines the optimal provisions that will govern your relationship just the way an arbitrator might if you left a gap. And so sometimes in writing about this, we talk about it as ex ante arbitration. You're basically you're committing to whatever outcome is in this algorithm, whatever outcome's going to come out of that box. You can't change the box anymore, but the inputs into it will change as the world changes. And so the parties are going to use that to tell them how to get over a bump in the road, how to perform in certain circumstances. With that micro-directed possibility, you can have self-driving contract provisions. And when we originally were writing about this, we thought that's what we're going to see first, because you're not going to have the technology to write the whole contract. You're going to write this provision or that provision. Although today, after the kind of popularity of ChatGPT and GPT-4, you can start imagining, no, actually, it'll write the whole contract. If we agree with the right data being put into the system to do whatever that contract says to do, when we come to the point, not when we didn't write it at the time of the contract, we ask it at the time of performance, then we get a fully self-driving contract. And in the paper, in the chapter, we give examples. We give dynamic pricing examples. We give examples of technology that determines when there's non-performance, technology that shows when a contract is out of compliance with the law. And we say, it could just rewrite itself every time the law changes. If non-competes are no longer allowed, those get deleted from the contract, right? And it can determine the substantive performance rules as things change in the world, as the law changes, as the facts change. And we give examples of each of these. I won't have time to do all of that, but I'll give two quick ones. Pricing, so auto insurance has done this for a long time. We will change the price of your insurance based on the data of how you drive. Home insurance, dental insurance do the same. There is currently technology that can tell you whether or not a court will read provisions one way or the other, and you could agree to just do what the technology says the court would do, which then means you don't need the court, and you make that your contract. Those are the kinds of things we play out in the chapter, and we show there are real-world examples of this happening. And then we ask, so what? What do we need? Why do we need to know this? Do we need to do anything? We do need to do anything. We need to think about, and the law needs to think about, these three questions. Who gets to draft that contract? The parties are going to decide, well, I want my algorithm. You want your algorithm. We'll probably hire a third party. Maybe the firms that do arbitration today will become the contract kind of keepers. Now, that's fine if the parties are sophisticated, but if we live in a world where it's a business and a consumer, we might want to regulate who those third parties are, because otherwise they get captured, they repeat players, they try to kind of push their own views down. They try to favor the large companies rather than the other side. What data do we use? We're not going to just use regular ChatGPT. We're going to want to train it on whatever's relevant for the contract at issue. And again, you're going to think about who makes that decision, what is the balance of power between the parties. And then the question is how do you specify the objective? Now, this is where I think the large language models really move things forward. When we wrote this, we're like, it's going to be really hard to figure out how to write an objective such that the computer understands it. But large language models are really good at writing code, and they're really good at turning I want this to happen into something a computer can understand. And so then you get kind of an interface that does that part for you. And you can say, well, we want a contract about selling grain, and we want to make sure we make the most money. What do we tell the algorithm to do? And that's an intermediate step that's now been, I think, bridged since we wrote the chapter. And so those are the things we explore in the chapter. We now have to think about what's next in the world, and I know I'm out of time, so maybe we'll do that in the Q&A. I will hand it back.
Thank you, Tony. Our next speaker is Professor Jeannie Paterson from Melbourne Law School, where she is the director of the Center for AI and Digital Ethics. Jeannie is an expert on consumer and data protection law in the context of emerging digital technologies. She will speak on consumer protection law. Over to you, Jeannie.
Ernest spoke about transparency, and transparency is very close to my heart. It's at the basis, algorithmic transparency is the basis of consumer protection in the age of AI, for some of the reasons that Ernest talked about, combined with access to dispute resolution, which I know is on the minds of many of our judges. It's also the basis of consumer law, and in fact you could rewrite a lot of consumer law statutes by just having rules about don't mislead people and be transparent, because if you do that, a lot of sharp practices are avoided. But you need one addition, and the Dean spoke about that addition. He spoke about the Industrial Revolution, and that's also very close to my heart. In fact, I've written an article on railways and consumer protection law, because the other thing that happened in the Industrial Revolution was that railways started, and railways injured a lot of passengers, and typically, railway companies excluded liability for injury using standard form contracts called tickets, and the courts tried to deal with that. They thought that wasn't quite right, but they were kind of bound doctrinally, and eventually we got statute. So the two key parts of consumer protection law, in my mind, are don't mislead people and fairness limitations on what you can contract out of, which is actually Mindy's written a lot about. And those two elements, don't mislead people, and limitations on what can be contracted out of, are really relevant when we're thinking about consumer protection and AI. Earlier today, I spoke about deepfakes and consumers. That's AI doing bad things to consumers. Today, I'm going to talk about consumers using AI to help them. Now, AI has tremendous capacity to actually address the information asymmetry that exists between consumers and businesses. consumers in principle can use AI as an information intermediary, a way of accessing information that can be particularised and personalised to their own circumstances to help them manage those big decisions in life that typically are quite difficult, and typically they're dealing with a larger company that has more resources, more information, and doesn't necessarily want to act in their best interests. So theoretically, ChatGPT can communicate with us, it can draw on some machine learning models to help us decide what investments should I make, how should I plan for my retirement, how do I teach my child, should my child specialise in French or Cantonese, what should I do about this spot that has appeared on my hand? My dog appears to have its hair shedding. What vacuum cleaner should I buy to deal with that? How often should I brush my teeth to reduce my insurance? And so on. So there's lots of potential there, but as we all know, there's also risks. And the risks are simply that algorithmic decisions or algorithmic recommendations are based on data. And if I, the consumer, am not represented in that data, I actually appear as what's called noise, which means the recommendation that comes out may or may not fit my circumstances because I'm not recognised. Or if the data, as we all know, is the data on which the algorithm's changed is based on assumptions about someone who looks like me, it may give recommendations that are tainted by historic bias about people who look like me. So, for example, famously, if we're talking about advice to people about what jobs they could take, or actually about what jobs they should get, people who've taken maternity leave aren't always recognised as being productive members of society and maybe have different recommendations about the jobs they could do than they're really capable of doing. So there's problems in the AI, inherently in the AI, about whether it actually will be able to provide the personalised representation that we're hoping for from our information intermediary. And then, as Ernest has said, there's also more deliberately manipulative possibilities whereby whoever's provided that intermediary may in fact have programmed it or trained it or rewarded it to give recommendations, advice, predictions that in fact aren't in my interests but are in its interests. So how do we deal with that? How do we enable the possibility of AI as an intermediary, an information intermediary to help consumers with difficult decisions while protecting them against bias, error, and indeed manipulation? Well, I would suggest that actually a lot of it lies in don't mislead people about the capacity of the AI. One of the things we're seeing at the moment is there's an AI hype cycle. AI can do everything. And the FTC, the Federal Trade Commission, has been quite robust in saying we don't want fake AI. We shouldn't be over-promoting AI as having the ability to do things it can't. So the AI has to be realistic, or the people who are selling the AI service to consumers have to be realistic in what it can do. That raises another question. How does the provider of an AI service convey to the consumer the scope of the advice that it can usefully provide? The AI might be very good at some advice and less good at other advice. How is that conveyed usefully to the consumer? Well, traditionally, as students of contract law, you know the answer. You write a small print, a fine print disclaimer which says, we take no responsibility for errors. Now, that's not going to cut it, right? That really isn't going to cut it. It's not going to cut it as a matter of fairness, and it's also not going to cut it under most consumer protection law. And actually, if we want people to have trust in the fact they can get information from AI, it's also not going to build trust. So the challenge for contract law here, or consumer protection law sitting on the top of contract law, is to work out how we can provide salient, meaningful advice to consumers about the limits of the technology that do not actually undermine their information autonomy but contribute to it. And if you think about it, AI has a possibility to do that too. Some of us are visual learners, some of us are word learners, some of us are oral learners. It should be possible to provide salient, layered disclosures to consumers about the scope of the technology they're using that is meaningful to them so they can benefit from the technology but not rely on it too much. And that's possible now, but it's also something that's prompted by the law. So that's the fairness point. We need the scope of the AI to be disclosed, but in a way that's fair and reasonable, consistent with people's expectations, meaningful to them. Consumers should also get service, the actual service that's provided to the consumers should also provide what's promised. It should be a good quality service. Within the scope that's defined, it should do what it says. How do we do that? Well, we know people that provide services to consumers are subject to a tort duty, often manifest in statute as well, of reasonable care and skill. What's reasonable care and skill when you're providing an AI-informed service to a consumer? Now let's get rid right away of that old furphy which floats around which says, oh, well, the provider of the service shouldn't be liable because they don't know what the AI might do when it's interacting with the consumer. I mean, that's a legal nonsense, right? The AI is a tool or a service that's provided by the deployer of the AI who is responsible for providing an AI that works. The real question is, what does it mean to exercise reasonable care in providing an AI service to a consumer? I'm going to suggest to you that that is changing as we know more about AI, as we understand more the need for transparency and explainability. And the answer also lies in those non-legal codes that we know are in existence, those non-legal standards, those non-legal codes, the ones that are in place in Singapore, for example. You have verify AI, goes one way or the other, which actually sets down the steps that a company should go through before it uses an AI to either make decisions about consumers or provide services to them. I'm going to suggest to you that that will become the legal standard of reasonable care should these matters be tested in court. And then we see the joining up of ethical and non-legal standards into private law. But 1 minute, and I'm going to make one more point. Many of the answers about how we want to interact with society as consumers don't, however, lie in the law. They lie with us. They lie with us in the values we believe in society and the sort of relationships we want to have with each other as people. Another furphy that often happens with AI is people go, oh, it's going to lead to cognitive decline. We're going to stop knowing how to think and read and create. I don't think that's true. I think that people who interact with technologies are creative and thoughtful and are challenged in what they do. I don't think AI will lead to cognitive decline. But I am worried about relationships. Some of you will know that already there's many products on the market that provide an AI relationship. Replica is one of them, but there are many, many more. We in this room know that humans are happiest when they are with other humans. We have a choice about that. We have a choice about how we interact. We have a choice about who looks after our old people. We have a choice about who reads stories to our children. That's the human question, not the legal question with AI. Thank you.
Thank you, Jeannie. Our next speaker is Professor Tan Cheng Han, SC, who needs no introduction. He has a distinguished legal career, having been the former dean at NUS Law and City U Law School in Hong Kong. He's an authority on agency law, and we are very lucky to have him contribute a chapter together with Professor Daniel Seng on agency law. Over to you, Cheng Han.
Thank you very much, Ernest, for the kind introduction. As Ernest mentioned, this is a joint paper with my colleague Daniel Seng. The only reason why I'm presenting it is because Daniel has another paper to present this evening. So today, as all of you know, there are many systems varying in sophistication. They're able to act on behalf of their users to meet certain objectives or complete tasks without direct input or direct supervision from such users. From a business standpoint, for example, we know about chatbots, voice assistants that can answer queries and, in fact, perform tasks or services for individuals through commands or questions from consumers. And many other examples, of course, exist, including systems that facilitate contracts being entered into, such as, for example, automated trading. And that was the backdrop for a very important Singapore case, the case of Coin and B2C2, right, dealing with mistakes because the system kind of did not operate as it should have operated, and that caused a lot of issues to arise. So what we do in our chapter, Daniel and I, is that we explore the legal effects of these systems where they act as, the term that's increasingly being used, where they act as AI agents, and in particular, where contracts are formed through the use of such AI agents. Now, I use the term agent somewhat inadvisedly because the term agent at law has a defined and somewhat narrow meaning, right? So here in this context, I use the term AI agents somewhat broadly, somewhat liberally, and in a somewhat non-legal sense. Now, because when we speak of an agent, typically we mean a person who acts as an intermediary between two or more other people, right? And to be more specific, to bring them into some kind of legal relationship together. The problem, of course, with these AI agents is that, in a sense, they're not really persons to begin with, right? So that's the first problem. But notwithstanding this, quite a number of academic commentators, particularly those from the US, take the view that highly intelligent and sophisticated systems may be considered persons. Right now, we are personally skeptical of this view, at least at this time, and we do not consider any of these AI agents to be agents properly speaking, and we consider them to really be extensions of their developers/owners. Right? So we don't see them as persons in themselves, but rather we see them as extensions or tools of the people who've developed them or who own the intellectual property to these particular AI agents. Now, one reason why some academics take the view that they can be agents in a legal sense is because they say, look, you don't necessarily need to have capacity to act as an agent for another person. And that's true. Right? You can have a minor who doesn't have capacity to enter into a contract on behalf of for the minor herself, but that minor is capable of acting as an agent for me so long as I have capacity to enter into the contract itself. Right? So that's of course true, but I think there is a fundamental difference between personhood on the one hand and capacity on the other hand. Right? The very example I've given, you have a person, a child, who has no capacity, right? So the absence or lack or presence of capacity does not really go to the issue of personhood, right? Another example given is they say, look at companies. Companies are regarded as persons. But then the short answer to this surely must be that companies are persons only because legislation says that they are persons, right? So the law has given them the status of a legal person through legislation, and we have to respect legislation, and that's why they have personhood. But there's a more difficult example given, which is that apparently, and I didn't know this for the longest time, ships are also considered persons for certain limited purposes, right? And there are a number of reasons why this was from a historical standpoint, and the reasons don't necessarily are not necessarily consistent with one another, right? One theory is it goes back to this principle of deodan, which is the right of the monarch or the crown in those days to actually forfeit something that has caused death to another person, right? And it's by way of extension of this particular doctrine. But I think the one that maybe makes a bit more sense to me, because I can't see how that's a logical extension of that particular doctrine, but the one that makes more sense to me is what another academic commentator has said, which is that American courts extended the idea of personhood to ships to enable the ships to remain under American jurisdiction even when traveling along the high seas. Okay, so that makes a bit more sense, and I can see the reason for this, but you can see that these are very historical reasons and very peculiar to ships, if you like. It's hard to see how something like this is kind of really analogous to artificial intelligence. Okay, so our view is that absent specific legislation, we do not think that intelligent systems can be equated to persons and legal agents. Right? But going beyond that also, the core of agency really at the end of the day is that the principal, myself, and the agent, yourself, we in a sense consent to that relationship of principal and agent. And consent must surely mean there's fully informed consent that comes voluntarily. But when it comes to artificial systems, however intelligent, right, they're not really capable of giving what humans regard as independent and fully formed consent. At least at this time, AI systems behave according to human-defined parameters, including not just the code, but also the statistical and neural network models generated by the code, however intelligent the system's behavior may appear. right? There are also other gaps with the theory of AI systems being agents. If it is capable of personhood and commits a wrong, what does it mean to bring a claim against an AI agent, right? Is an AI agent capable of owning property, right? The answer would appear to be no. And we therefore ask, even if AI is a person, what good will it be if there's no practical way of obtaining any remedy against such a person, assuming that assuming that person has done some wrong, and a claim in tort or breach of contract or whatever else can be brought against such a person, right? A right without any real remedy seems useless to us, and therefore we also think that it doesn't do very much good at this point in time for an intelligent system to be labeled a person. And that's also another reason why we think the whole thesis doesn't make sense. So the reality, therefore, to us is that AI systems are tools, those sophisticated ones, that are the property of their owners/developers. They are the means or medium through which their owners may contract directly with third parties, but they're only tools. And actually, these tools have existed for the longest time, although in more unsophisticated forms. For example, the position is similar to a US case in 1933, where a device automatically dispenses gas upon receiving a coin deposit, right? That's also, in a sense, a system that acts as a sort of mediator, right? Without any human intervention, so to speak, beyond putting in the coin deposit, right? Or a parking contract is formed through a ticketing machine at the entrance to the car park, right? The famous 1971 English decision of Taunton and Shoe Lane parking, right? Or closer to home, or website that automatically process orders and send confirmation emails, right? All of you will know the case of Chui Kin Keong and digilandmall.com, right? So today we think that these artificial intelligence systems are just more sophisticated versions of these older forms of contracting, right? So what if at some point, right, because I think it will happen at some point in time. I'm a Star Trek fan, and I think one day we will see Data, the character, right? So what if at some point AI systems achieve such a high level of intelligence and consciousness that we can say they are sentient beings, right? Even so, we would submit that absent legislation, it is unlikely that such systems would be regarded as legal persons, right? Human beings are automatically regarded as persons, right? Outside of this, we think there must be some legal intervention. Therefore, absent any real legislation, we think that this is not likely to happen. And we also think that as a matter of public policy, legislation is important because you will always need guardrails, right, to protect against certain gaps that would otherwise happen. For example, in company law, one of the guardrails is disclosure. Right? Through disclosure, you know who you're contracting with and what that entity is all about. You probably need something similar or analogous in the case of artificial intelligence as well before they can be safely recognized as legal persons who can incur legal obligations. On that note, thank you very much for listening.
Thank you, Cheng Han. Our next speaker is Professor Kelvin Loh from the University of Hong Kong. Kelvin is an expert in property law, including digital assets. He will speak on property law. Over to you, Kelvin.
Thank you, Ernest and Phillip, for inviting me to participate in this project. I have actually got two co-authors for this chapter, Wan Wai-Yi, who is Dean at AGC Academy, and Wu Ying from Seoul National University. The paper is actually a bit wider than property law and AI. It's personhood and property and AI. So if you study private law, you will know that the two main things we look at are objects, which are property, and subjects, which are persons. So we kind of delve into both in this paper. It's a pretty wide-ranging paper. We cover 3 different topics, and they probably don't look recognizable to you as AI because Ernest and Phillip were kind of ahead of the curve. This was before ChatGPT took off, so it asked us to take a very wide view of AI. So the first part of the paper considers prosthetics or cyborgs, right? So there's a theory out there that if we treat prosthetics and as objects or things, we may end up undercompensating or underpunishing when somebody interferes with another person's prosthetics. And we take the view that this is slightly out of proportion, because if you some of this research looks at sentencing baselines, but the problem with sentencing baselines is there's wide discretion, right? So actually, once you take into account the discretionary element, I think, this problem sort of goes away. Now, if you're talking about private law damages, this might be a more serious problem, except that we're not sure that trying to treat an object as part of a subject is really the answer to this. And those of you who have studied property law under me will know that the law of fixtures is a very painful and very confusing topic. And those of you, who are familiar with the paradox of Theseus's ship will also be familiar with the problem. It's a problem of identity. How do you say that something has either kept its identity or changed its identity or lost its identity? Now, one good thing about trying to treat this under, accession of fixtures is that, a bit like land, we don't have to deal with the problem of which is the minor and which is the major object. But you still have the very difficult problem of when does something cease to be an object and become part of the major object. And if you look at surveys on how people with prosthetics actually regard their prosthetics, there's no consensus. And some people will sometimes regard their prosthetics as part of themselves and sometimes not. So we suggest really that if there is a problem, the problem is better addressed by taking more seriously emotional distress, right? The law currently is very dismissive of emotional distress. And part of the problem really is that we've never really been able to see it. But actually, there are physical markers, and we're beginning to be able to see the physical markers of emotional distress and mental distress. Now, some judges dismiss emotional distress, mental distress as temporary, but cuts and bruises are temporary as well. We pay damages. So this can be addressed by having, modest sums of damages rather than trying to get ourselves in this tangle of accession. Now, the second part of the paper deals with a topic that probably is more of interest given today's AI hype, and that is whether we should confer personhood on AI agents. This is something that Cheng has already talked about. Completely agree with Cheng and Daniel that this requires legislation. But what we consider really are the cases, right? So what cases can you put forward to conferring personhood on AI? Broadly, this divides into either the moral case for personhood or the utilitarian case for personhood. Looking at the moral case first, I'm not going to go into it because it's fairly deeply philosophical, but we don't confer personhood to clearly intelligent animals, right? So intelligence is not the sufficient standard, all right? And one of the reasons why we don't is because we don't really understand them. So many of you will be familiar with the Naruto monkey selfie case, right? Somebody put a camera in a forest in, I think, Indonesia. The monkey took the camera, took a selfie. The person who put the camera there claimed copyright. Peter sued them, right? And then at trial, when Peter saw that his case was not going very well, Peter collapsed, settled, because Peter didn't want, right, to endanger its own objectives, right? So if we cannot actually communicate directly and clearly understand AI systems, just as we cannot communicate directly, clearly understand animals yet, then conferring personhood requires other people to act on their behalf, and this risks people taking advantage of these persons to further their own objectives, as Peter did in Naruto's case. We then look at the utilitarian case for personhood, and we agree. In theory, conceptually, we can confer personhood to anything we want, right? Because what are companies but legal fictions? The difference, however, is that companies serve a useful purpose, right? They serve a purpose of ring-fencing assets and therefore encouraging entrepreneurship. What purpose does conferring personhood on AI systems serve? Now, some people say that, if you confer personhood on AI systems, then you can bring claims directly against them, whereas currently you don't know who to sue. Is it the deployer, the developer, the person who manufactures the body that embodies the AI? So, you have a clear person to sue. Now, obvious problem, AI has no assets. So you've got to kind of create a patrimony, right? Basically a set of assets and liabilities. And if they're not sued, this patrimony goes to waste, right? There's also the other problem. If, as we think, there are numerous problems with corporations law, holding companies accountable, both criminal law, holding managers accountable, right? Then until we solve that problem, I don't think we should be extending this problem to AI. Plus, of course, companies are what we call socio-technical organizations, whereas AI would be purely technical organizations. Many of the rules that we have for companies will not translate very well. How do you lift the corporate veil? Who do you lift the corporate veil against? There are no shareholders, right? Are there directors? So until we solve that particular problem, we don't actually think that, even though we could, I don't think we should, right? So basically, we don't see either the moral or the utilitarian cases for conferring personhood on AI being made out. And finally, we look at data, which is basically the new oil. Data is the new oil. And there's a lot of pushback on data collection, using data for training AI. And one of the ways people have been pushing back, I think you'll hear a bit more later from my colleague, my former colleague, Ying, is that people are beginning to assert property in their data. All right. Now, the problem with trying to say that you can have property over data really can be summed up by paraphrasing something that J.W. Harris said in his paper on ownership of bodies. All right, so if you take out bodies and you substitute data, and I'm going to quote him, right? The fact that people deploy possessive pronouns in relation to their data is in itself no indication of ownership assumptions. My, yours, his, or hers may signify a host of relationships which have nothing to do with owning. Even a child will not confuse the sense of my as between it's my ball and she's my teacher. All right? So that's precisely the same problem. If you try to say that this is my data, therefore I own my data, therefore I can prevent you from using my data, it is an entirely circular argument. Now, I'm not saying, right, that your data should be capable of being freely used. I'm just saying that data is not the object of property rights. Now, can we make it the object of property rights? In theory, yes. Do we want to? It's a different question altogether. At least up to now, no legal system I know of recognizes property in information. Because obviously, if you recognize property, and we're talking real property rights, meaning the right to exclude everyone to information, you're going to impede the free flow of information, right? You're going to impede free speech. So I think my time is up. So those are the three parts of the paper. Thank you.
Thank you, Kelvin. Our next speaker is Assistant Professor Ying. She obtained her JSD from Yale, and her research interests include privacy and data protection, property law, and law and technology. She will speak on unjust enrichment and AI. Over to you, Ying.
Thank you very much, Ernest. So my chapter starts with a very simple question. So we all know that companies, they collect a lot of information about us, and they use it to train their AI systems, and they use it for all sorts of other purposes. So are we entitled to claim some of those profits that they make? Okay, so a natural starting point would be contract law. Okay, so after all, whenever we sign up for a service, we are required to agree to a very long list of terms and conditions, and sometimes we see privacy policies as well. Okay, so we don't usually read them, but if you read carefully, you'll notice that we have all granted Google, for example, a worldwide license for free to use our data to train their AI systems, and for many other purposes. Okay, so if those terms are actually binding on us, then that will be the end of the matter. But there are two other possibilities. The first one is, for some companies, they don't really have terms like this. That's an easy matter. And second of all, even if some companies have terms like that, they may not necessarily be binding. So we do have a line of cases saying that privacy policies, for example, they're not really binding contracts between us and those companies. So in those situations, I ask, is there any cause of action that we can rely on to say that, yes, we can sue those companies to claim at least part of the benefits they receive as a result of using our personal data? So the one I come up with is unjust enrichment. Okay, so what are the elements? The first one is we need to show that the companies are enriched. Second of all, we need to show that the companies are enriched at our expense. And the third one is we need to show that companies have been enriched in circumstances that would render it unjust for them to retain the benefits. So this element is usually referred to as unjust factors. Okay, so that brings us to the first interesting question. So what benefits, if any, has been transferred by us to those companies? So it cannot be the personal information itself, like Kelvin has mentioned. We retain that personal information. It cannot be the digital files, which are the digital binary representation of our information. Because those digital files are created by the companies, not by us, not transferred by us to the companies. It may not even necessarily be the use value of our data for a particular purpose. Because as we all know, data as information is non-rivalous, meaning that a company can use my data for a particular purpose without preventing me from using my data for the same purpose or other purposes. So my conclusion is that what is being transferred is control over data. So as the companies acquires the power to determine the use of my data, my power to determine the use of my data diminishes. So that's the thing of value that's been transferred from me to the company. And of course, that brings us to another difficult question. How do we assess the value of that control? So in my chapter, I offer a few possibilities that the court might want to consider in evaluating the value of this control over data. So for example, some companies unfortunately sell our data. So that would be an easy case. If there's a sale price, then that can be used by the court as evidence of this value of control over data. So other times, the companies may save costs by using my data. So they don't have to hire real people as focus groups, for example, to learn about their preferences, about their products. They can use my information instead. So if they have saved costs, again, the costs saved may be used as a factor to determine the value of the control over data. And of course, sometimes there will be studies about how much value people actually place on certain types of data. So on and so forth. So maybe the court can try to use those factors to determine the use value or the value of controlling our personal data. But then we also have another more difficult question. which is under what circumstances will it be unjust for the companies to retain the benefits of, or retain those benefits? So under unjust enrichment law, as we all know, there's a long list of unjust factors that the courts usually rely on. So those are well established. So for my purposes, I say that 2 of those unjust factors are particularly relevant. The first one is mistake. So the argument goes like this. Okay, so I transferred my personal data to the companies due to a mistake. And I would not have transferred my data but for that mistake. And therefore, it would be unjust for the company to retain that data, or at least retain the benefits. Okay, so one possibility about such mistakes would be, for example, my mistake about the company's data security practice, or how the company uses my data. So if I were to know that company uses my data for some illegal purpose or unethical purpose, I would say that I would not have transferred my data, but for my mistake. And the second possibility would be relevant in a particular situation. So sometimes we pay for their services and their products, and at the same time, the companies will make a promise to me and say that, oh, we will not collect your data, or we will not use your data for a particular purpose. So in that case, I can argue that I have actually paid for that promise. So if subsequently the company failed to keep that promise, then I would say that you have received payment for a promise, you failed to keep that promise. So it would be unjust for you to keep the benefits, to keep the payment. So that would be another situation where arguably we can use unjust enrichment to claim some of the benefits received by the companies. Okay, so that sums up the first part of my paper. And in the interest of time, I'll just be very brief about the second part, which is about the remedy of disgorgement. So in the chapter, if you're interested, I go through all the academic arguments that talk about how we can justify an award of disgorgement in certain cases. And I use those arguments to say that maybe we should also, it is also we can also justify an award of a disgorgement in certain types of cases where the companies either misuse our data or maybe collect our data without our authorization. Okay, so that will be the end of my presentation. Thank you.
Thank you, Ying. Our next speaker is Associate Professor Anke Moerland from Maastricht University, where she's the Vice Dean for Research. Anke is an expert on IP law and policy. She'll speak on IP and AI. Over to you, Anke.
It's my pleasure to actually introduce a few things that I discuss in the paper. Try to limit myself to 5 issues, and that have to do with the question of copyright protection and patent protection. So these are the 2 areas of IP I will cover. I won't go into trademarks today. And the difference here lies between, on the one hand, getting a protection for the AI system, so the technology, the algorithm, the model, and then also asking the question, is there copyright and patent protection for products, output works that are created with AI? So either humans assisted by AI, or in the future, arguably, generated by AI. As an academic, we are free to think about the future because right now, not so many things are clear, so there's more questions than answers maybe. But then we have the opportunity to go into theories, like you also just did, in the idea of property rights, IP rights. Why do we confer IP rights? And clearly, we want to incentivize creative and innovative works and ideas that fulfill a certain need in society. And we do this by then also making them public so that everybody else can further innovate on that, that they would maybe not do if there wouldn't be such a property right. But I think there are two important questions, and you will see it later in the presentation, that are worth being asked. Namely, is there a need to confer property rights on AI systems in the first place? Because would we otherwise not see the development of AI systems, right? This is the idea of, do we actually need an incentive? The other relates to the AI-generated output in the future when there is no human anymore involved. Also here the question is, do we actually need a compensation of that output that is generated by an AI where there has already been a compensation of the AI system that generated the AI? That would then be double compensation. Let's start with AI systems and ask what protection is available here. Can be quite brief on that first aspect of copyright protection for computer programs, code, algorithms, models. As long as you can express an algorithm in a code that is machine-readable language, this is still a literary work and can be protected by copyright if it is original. So if you have expressed in your intellectual author's creation, let's say, there. But the scope of protection is also only limited to a production right, mainly, so the copying of it. So if a code makes a robot raise his arm, that effect, that function, is not protected by copyright. So it's only the literal or illiteral sort of copying of the code itself that would be a problem, but not the function that you can also achieve with another code. Patent protection in that sense is much broader and relates to the function. But here we have to ask the question, what can we patent? We can only patent technical inventions. So algorithms or software as such are abstract, basically ideas, and they are not directed to a particular technical result. And that's the problem that we are trying to remedy. And there is an answer. The answer is that you have to claim, and in patent law it matters how you write the patent claim, you have to claim the use of an AI system in a particular apparatus or device in a computer, and that use of the AI system in this apparatus has also a technical result that achieves a certain solution to a technical problem that was defined in the first place. One of the difficulties that I describe also in the paper is the question of how do you sufficiently disclose the AI system? Because patent law is based on a social contract idea. We provide you with a monopoly right, but at the same time you need to make public how that invention works. So how does the AI work? Does that involve disclosing the data with which you have trained the AI system? And here we are seeing different case law. In the European Patent Office, a decision was made, and I think that's a reasonable one, that it is required to disclose at least the selection on which you have made the input data, the criteria, but also a data set that is suitable to solve the technical problem that you have described. So it is required to actually also show that. Let's look at the output side now. What type of IP protection is available to works and inventions that are created with AI? And here I want to start with the important question of, can an AI system be considered an author and an inventor in the first place? And here we go back to the standard of what is an author under copyright law as we know it at this point. The connection between the author and the work is so strong that we only allow protection for a human created work. So if there is no human anymore involved in any of the steps of creating a creative work, we will not have copyright protection for that, right? For the inventor, it has been a similar decision that we've seen all over the world, the important Davos case, where a group of attorneys brought together a patent application to all sorts of offices around the world to see what will happen if the inventor, and the name of the inventor is actually the AI system. And all these offices, except for South Africa, because they are only making a formal examination at that stage, so we can also not conclude that they are following that, the opposite, but all countries so far have said no. Also here we need a human inventor. Sorry, and the human inventor can be anyone in the conception of the actual invention. So also selecting the output that the AI has made and identifying this as the most effective and inventive output could be considered to be sufficient in terms of making a substantial contribution to the intelligent and creative conception. But for the future, would that be possible, potentially, to name the AI system as an author, as an inventor, sorry. And here I think the answer lies similarly to what my colleagues have said before. That would require legal personality, legal personhood on the behalf of an AI system, so that it can be also the owner of rights and obligations. And that is not the case. So IP law comes sort of as a second or third step before we first have to solve other private law questions. So copyright protection is only available when there is an AI-assisted work. As I said before, when we are moving to AI-generated works, it won't work anymore because a human has to be involved according to copyright law, whether at the conception, at the execution, or at the redaction stage. It could be that we think about a neighboring right that's not copyright, but a different right that relates to authors' works, but currently this hasn't yet been installed by any jurisdiction so far. Finally, patent protection is possible on output that is created by AI, again, when there is still a human inventor, as I said before, as long as the invention fulfills the patentability criteria. So it has to be inventive, it has to be industrially applicable, and it has to be new. One of the questions we are facing right now in that assessment is when an AI was involved in the creation, how will the person skilled in the art, so that is the notional term with which we decide whether actually this invention was non-obvious, not something that routinely people would do at this point. But if it is routine work to use AI in the development of, technical solutions, drug discovery, and so forth, we are going to raise the bar, the threshold of inventive step, and that will make that less inventions will be patentable. The results are a bit of a moving target, so I would highly recommend to keep this area also in sight, because things are changing, as I tried to explain, as everybody else has noted. We see that there are copyright and patent protection for AI systems under certain conditions. We also see that copyright protection is available for AI-assisted works. Patent protection does not exclude AI-generated inventions, but here the question really remains, is it justified to provide property rights, IP property rights, patent rights to a machine-created output in light of the double compensation argument I've made before? Thank you very much.
Thank you. We saved the best for the last. Our final speaker is Associate Professor Daniel Seng, who is co-director of TRIL. Daniel received his doctorate from Stanford Law School. He's an expert in information technology law. He will speak on information intermediaries. Over to you, Daniel.
Good evening, everyone. I'm conscious of the fact that I stand between you and a question and answer session. especially since it's a long day for us, so I will be reasonably brief. Nonetheless, this is a very important and actually quite complicated topic, and there is a lot of historical baggage associated with this, but I shall begin. Today, some of the most powerful companies in the world are information intermediaries, companies that do not actually create content or control content, but merely provide access to content. These companies obviously need no further introduction today. The question for consideration is the difficult one of how did they get to be where they are today? How did they get to be so powerful? Of course, the easy answer is these two guys made it possible. Okay, Vince Cerf on the right and Tim Berners-Lee on the left often go around wearing these t-shirts to say that they didn't invent the internet and they didn't invent the web, as the case may be. But the true answer to the lawyers in this field is these two pieces of legislation. The American pieces of legislation, known as the US Communications Decency Act, or Section 230 of the CDA, and the US Digital Millennium Copyright, or DMCA in short, Section 512. I'll return to these two pieces of legislation again and again in my brief presentation. The CDA, Section 230, is extremely brief. You have probably never encountered a shorter section than this. It just simply states, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. And that's it. This critical piece of legislation has given rise to numerous problems. Of course, it was initially designed to promote and preserve free speech on the internet. But it has a lot of severe consequences when applied to its logical conclusion. I will introduce to you two case studies on the CDA. The first is the Jane Doe No. 1 decision against Backpage. Some of you may be familiar with a website like Craigslist. It's a personals website where you can advertise any kind of advertisement that falls into any category as long as it's suitable to your imagination. Well, if your imagination encompasses adult-themed advertising, then of course Craigslist was for you until Craigslist moved all the advertising and cancelled those under political pressure, and the advertisers switched over to this company called Backpage. Now, I didn't want to go into the sordid details of this, but apparently the categories included escort services, erotic services, and personals. The plaintiffs, who were minors, alleged that advertisements for commercial sex services targeting them, known as sex trafficking, were posted on Backpage by numerous third parties. The advertisements were made obviously by traffickers who had coerced these minors to sell their sexual services. They accused Backpage of facilitating this process by doing the following: selectively removing victim support posts and law enforcement sting advertisements from Backpage, and anonymizing features for the advertisers, removing metadata for certain photographs that were uploaded onto Backpage, crippled its own automated advertisement filtering system such that keywords such as, I shouldn't read that here, in this august audience, were all made possible, and also accepted anonymous payments. Notwithstanding the high bar that has been met by the plaintiffs in this case, the First Circuit ruled in favor of Backpage and said Section 230 of the CDA applied. Well, obviously the court said you are not a publisher or speaker of any information, because even though you have manipulated the content in question, these are considered editorial choices. Now, this decision didn't sit well with the US authorities, and in the end, they resorted not to Section 230 of the CDA to solve the problem, but to use FBI to seize the website under certain claims for violations of federal and state sex trafficking laws. The second case study which I shall draw to your attention concerns, of course, our number one internet intermediary in the world, Google. There was a class action maintained in 2009 against Google for enabling clickbait advertisements. Some of you may have encountered this when you go onto Google search engine, you type in the word free or free something else. You will be inundated with advertisements, in this case here, free ringtones, and if you try to click on them, the advertisements will take you to non-free ringtones. In other words, mobile subscription services. So the plaintiffs tried to maintain a class action against Google for essentially enabling these mobile paid subscription services to use Google's advertisement services to profit from the consumers. The action was again dismissed, and the reason given was Section 230. And the reason offered by the courts was, to say the least, curious. The court said that Google merely provided advertising bidding frameworks that could be used for either proper or improper purposes, and essentially the control or selection of the keyword and content was really left to the advertisers for their nefarious purposes or non-nefarious purposes, as the case may be. In other words, as the court said, the selection of content was left exclusively to the third-party user. Google's use of machine learning to, in a sense, redirect the users to the use of these search terms, and the propagation of these advertisements was held to be neutral. Now, for those of us who are familiar with EU jurisprudence, this term struck a chord because the ECJ also mentioned this similar concept of neutrality in its famous Google AdWords case in Google versus Louis Vuitton, which of course was also referred to in the L'Oreal and eBay case. Okay? This, of course, gives rise to lots of concerns about the potential overreach of the CDA. But lest you think that the CDA is a figment of the Americans' imagination, unfortunately, the Europeans have assimilated that lock, stock, and barrel into their own legislation as well. I'll say more about the EU Digital Services Act, which succeeded the EU e-commerce directive. But do you also know that the CDA is in Singapore? So Section 26 of the Electronic Transactions Act has our own replica of the CDA, which I've set up for you. The next piece of legislation which concerns me tremendously is the Digital Millennium Copyright Act. On its face, it's an improvement to the CDA. It no longer offers the intermediaries in question complete immunity. In fact, it offers them what is called conditional immunity. Intermediaries who are trying to grant access to copyright information are exempted from copyright liability if and only if, upon receiving takedown notices complaining about the copyright infringement, act expeditiously to remove the notices. So these are the conditions attached to the DMCA. And like many pieces of American legislation, they went worldwide, they went viral. In Singapore, we have them. In Europe, they have them. The DMCA is found literally all around the world. It's even in Chinese law. The original intention, as designed by the drafters of the DMCA, was to have the legal officers of the network service providers individually flip through notices, look at the complaints, and decide for themselves whether or not to disable the allegedly infringing copies of work on the internet. Guess what happened? Machines. Okay? So this is what actually happened. Not terminated machines, but very close. In a piece of research that I did for my doctoral thesis, I plotted literally the rise of machines in the DMCA system. In 2011, you had 4 million takedown requests processed by all the internet intermediaries in the US. When it reached 2015, the time for my graduation, my doctoral supervisor said, you better graduate because otherwise you'll never be able to beat the machines. So that's why I tried to graduate and stopped the chart. And 2015, the number had reached 565 million. Today, Google processes 1 million takedown requests each day. And obviously, this is because the machines are issuing the takedown notices. Humans are no longer doing that. As a consequence, Google is also processing the notices by machines. So literally, it's a case of machines versus machines. And the question that is asked is, are these machines doing a good job? And there's a piece of research that I did called Copywriting Copywrongs. And the answer is they're doing a terrible job. Okay? Up to 10%, maybe even 12% of all the requests and notices are riddled with errors, perpetuated on the part of both parties. I'm ending soon, so I'll just give a few anecdotal situations. So this is one particular example. A couple of years ago in 2013, there was a meteor outburst over Russia, the Chelyabinsk meteor explosion. And when some people in Germany tried to share the on YouTube their vehicle cam recordings of this historic natural event as captured on their car cams, they were filtered out by YouTube's algorithm. And the reason is that in the background of these videos, there was a radio that was playing that contained copyrighted music. Barely audible, but the algorithm picked it up. So in Germany, you can't see these YouTube videos. Another example would be the fact that intermediaries like Google are actually harnessing AI to power their own systems. And this is, of course, a joke, a play on Google's capture systems, where you are told, of course, you have occasionally encountered this, please identify if there are any bicycles in the following like 12 pictures, and you repeatedly do this again and again. And the reason is Google is actually training its machines based on your captures. That's what it's doing. So maybe eventually we'll get this, right? If you know what this pun is all about, you will laugh at it. It's Sarah Connor, by the way. So the question that arises for me, and the bigger picture is, what is therefore the modern day role for intermediaries in censorship and combating misinformation? On the one hand, they are not exposed to liability because of the CDA. But on the other hand, we need them to manage information. Of course, Malaysia recently found this out the hard way when it tried to implement its own rules for filtering misinformation and censorship. And it came in for a fair bit of attack from the online community about its DNS rerouting mechanisms. And also at the same time, if you remember in the bad days of COVID, the Biden administration had tremendous difficulty getting the websites to disable the misinformation sites that were saying vaccinations were bad, so on and so forth. I'll just skip through this and just share you some of my broad thoughts regarding the problem on hand now. So I think the CDA immunities are here to stay because they've enabled the internet to be what it is today. A reasonably free platform that allows for quite a frank exchange of ideas. But on the other hand, there are extremists and extreme views that have to be countered. So we need to balance the presence of the immunity rules with stronger content regulation. But how do we achieve this? Well, in Singapore, we've done this by a plethora of legislation. The number just gets added every year, okay? They all end with MA or OA, as the case may be, right? POFMA, POHA, and OCHA, as the case may be. And the sad fact, unfortunately, is that many of these rules appear to turn to automation as a way of content regulation and censorship management. So the prime example is, of course, the Digital Services Act and the EU Copyright Directive. The debacle over Article 17 of the Copyright Directive, for which I have no time to talk about today, really centers around the use of machines to manage and disable copyrighted content that's been put up on the internet. So I think the long and short of it is that maybe it's time for us to relook at these internet immunities that are created courtesy of the DMCA and the CDA and ask ourselves where these sit in relation to the broader need for us to recalibrate the availability of information on the internet while minimizing the chilling effects of censorship. And we have to find some kind of international consensus to solve this problem before machines make it totally impossible for us to do so. Okay. On that note, thank you very much.
The floor is now open for questions. Who'd like to start? Well, let me start then. And we'll take our cue from Tony's presentation. What next? What are we all going to do next? If I could invite speakers to just give one or two sentences of having written their chapters or having edited the book, what do they intend to do next about AI? Let's start with Ernest. What next?
I think as I mentioned very briefly, explainable AI is extremely important. The EU has the presumption of causality. The EU has imposed legal duties on the part of developers to identify and to record their inputs. And so the question is, for those jurisdictions which do not follow the EU legislative provisions, what kind of steps are the regulators taking to ensure that there is fair, consistent, and thorough recording of the inputs, and how should these inputs be properly disclosed with regards to compensation claims?
Thank you very much. Tony, you said what next?
Yeah, so I think the two big things come to mind, and I mentioned a little in the talk, is the data question. And in the self-driving contracts area, it's what data do you need or want to use when you're designing these contracts? And the ChatGPT LLM world makes this even more relevant because, as I said, like there might be an instinct of someone just to go on ChatGPT and be like, write me a contract. And that's not the way law firms are doing it. That's not the way sophisticated parties are doing it. So you really need to kind of figure out, parties need to figure out where the data is to make the right kind of predictions. And then this goes into what other people talked about, like who has the rights to that and what do we do with it. And the last thing I'll say is with the question of people just going on ChatGPT, there was an opinion last week where an 11th Circuit judge just went on ChatGPT to ask the plain meaning of a statute. Then he puts it in the opinion. He's like, this is what I asked, and you know, that's the instinct. And he doesn't grapple with what's the input into that output, and that's really important in any of these questions. And so the parties have to figure it out, and then the law has to figure out what to do with it.
Thank you. Jeannie, you said this morning that you had a lot of second thoughts about what you should have included into the chapter, but didn't. What will you be looking into as a matter of priority now?
Well, I think I agree with Ernest that explanations and transparency are very important for responsible AI. But for consumers, and I think somebody made this point yesterday, consumers don't have time to be investigating whether the AI that relied on was transparent and what the explanations are. So the next thing I'm doing is looking at dispute resolution, actually. Both dispute resolution by ombudsman. We rely on a lot of industry ombudsmen in Australia to use an inquisitorial as opposed to an adversarial response to disputes by consumers with providers of essential services, and I'm interested in how ombudsmen can respond to the use of AI, but use AI to make their process more efficient, and also small claims, which we were talking about earlier. How can small claims courts use AI to make dispute resolution more accessible, more efficient for consumers who simply can't go to court about these issues?
Now, Professor Tan and Kelvin, let's put you both together, because if I've understood you, you've said that, well, there's no basis on the law as it now stands to give legal personality or to say that AI has legal personality. You need legislation. Do you think that we should have legislation giving legal personality to AI? Looking to the future. Professor Tan.
Thanks for the question. I see no reason at this point in time. I agree with Kelvin. There's no good reason to do so. What I think is more important in what next is that we need to clarify some of our private law doctrines in the light of AI. I think the case of COIN and B2C2 gives a good example of how the traditional principles as applied don't fit very well, and I rather prefer the dissenting opinion of Lord Mans myself. Right? So I think that, to me, is more important, to try to discern the spirit behind our private law rules in the context of AI and see how they should be applied in that context.
Kelvin.
Well, I don't really see a big achievement in AI anytime soon. I think we've hit a wall with how much data can be swept up. So until there is another big jump, I don't think we're going to come anywhere close to crossing the line where I would change my mind and say there is now a good case for legal personality.
But let me try to change your mind on another matter. Is there any point to say giving AI or allowing one to sue AI in the same way that one is able to sue a ship as a thing in order to get control over whatever the AI comes with, the AI system, whatever rights the AI might have, make it an in rem claim against AI? What do you think of that?
Well, you first have to clarify what the object is. So what do you mean by AI? Are you talking about the computer that it's running on? Are you talking about the algorithm? Are you talking about copyright? to the algorithm? Are you talking about patent rights to the algorithm? Are you talking about trade secrets? In which case we're talking about law of confidence. So some of these things can be seized, right? Just like you can seize and sell anybody's property. Some of this can't be seized. So, trade secrets can't be seized. Right? You can acquire them because, as Ying mentioned, information is non-rivalrous. My possession of information doesn't prevent you from being in possession of information, unlike microphones, which are rivalrous. My control of this microphone means no one else has control of this microphone.
That's a really good answer. That's a really legalistic answer from a law professor. But I'm also going to say, if we treat AI as having personality, then we've all of a sudden fallen into the trap of, I think, removing the technology from the companies that develop it. And we want the companies that develop the technology to be responsible, so they need to be responsible. And so I would say there's a policy reason.
Yeah.
So I don't know whether I mentioned earlier.
Well, we'll cut you off there, and we'll give this half a chance. Ying.
On that issue, I did actually write a paper about legal personhood for AI for the purpose of criminal law. So I take a completely different stance. So my paper tried to set the minimum conditions that we need to satisfy before we can treat AIs as legal persons. So I think for the purpose, if you're interested, you can read my paper. So there'll be certain requirements that, so I think that's a distinct possibility that there will be good reasons for treating them as legal persons for the purpose of criminal law. So.
Thank you very much. Anke, reading between the lines in your presentation, I thought you were looking forward to the day when AI would have legal personality.
Okay, I'm rethinking what I said, but I think the issue, what I wanted to highlight, is that we need to think about what type of society we want to live in, what do we want to incentivize, and how do we achieve that? Do we need to incentivize sort of the further development of AI or the generation of inventions through AI or creative works? I think we do, but we may already do that through certain property rights that are already existing. Whether we now confer personhood on an AI system or not, the owner of that AI system may already been compensated. So I think that is an issue with property rights where we really need to ask these fundamental questions. What is the justification of sort of conferring further rights on a particular entity? What I'm concerned about, and also in the future I would like to look a little bit further into this, is the question of how can we balance products and creative works that are coming from AI, but at the same time not stifle the creativity and the innovative activities by humans. And I think that's really where I would like to look at other potential mechanisms of getting a compensation and actually fostering also human activity, which may not be so obvious to how to do this right now. So I mean, that's really an issue for the future.
We're 2 minutes beyond time, but I'm going to trespass on the audience's patience for another 3 minutes. I'll ask Daniel a different question altogether, and that has to do with, in her recent book, Digital Empire, Anu Bradford identifies 3 types of data protection, data privacy regimes. One is the US model that prioritizes freedom of information. Another is the EU model that puts a priority on human rights. And the third is the PRC model that is similar to the EU model, but puts a priority on national security and the use of data or data protection limited by considerations of national security. Where does Singapore fit in, and which model do you think Singapore should be proceeding on?
I think the answer to this reminds me of the Star Trek clip where I think it's General Akbar, right? That's the fish head general, and he is exclaiming, "It's a trap." Okay, so I think it's a trap question because I can't speak for the government's approach to the management of personal information in Singapore. The move has been to essentially empower businesses to process personal information albeit at some minimal costs to the observance of data protection rules. But it's actually been business-driven or business-oriented. That's, I think, unfortunately, neither US nor EU nor the Chinese model. So I think our model is quite unique in that sense. So that's why I think it's a trap answer.
So we should be proposing to Professor Bradford that she should amend her book and add the Singapore model. I think that concludes what we have to say. I will just reveal one bias in fairness. I tend to side with Ying. I've read Jacob Turner's book on a robot AI, and I've been very much convinced by his arguments on legal personality for AI. But that's a subject for the future. That's a subject for perhaps a discussion amongst everyone. Thank you very much for attending. Thank you very much for all our contributors. And thank you very much for NUS for sponsoring this. Thank you very much to the Dean.